Okay, listen, I think we should start since we're already 2 minutes behind schedule. I'd like to welcome everyone, if I may, to the high-level roundtable on rethinking antitrust law. Those of you who don't know me, my name is Paul Hoffines, and I'm the president and co-founder of the Lisbon Council, and I'll be your host for this session here today. Look, we have two very distinguished speakers, Jonathan Faull, 3 times Director General and former Deputy Director General of DG Competition, and Doug Melamed, who joins us from a long way away. Doug, in our meetings in person, we usually have something we call the Frequent Flyer Award, which goes to the person who's coming from the farthest distance away. And I think even though you haven't traveled at all, we'll make you honorary Frequent Flyer champion for phoning in so early in the morning from where are you, in Palo Alto now?
Yeah, Palo Alto.
But, well, I'm sure the weather's nicer there than here, which probably isn't saying much. Professor Douglas Melamed, who had a long career in the private sector before going into government, where he held a series of distinguished positions. I'll introduce him a little more directly in a moment. Look, we're meeting at a very interesting time, obviously. There's a lot of issues in the air, some of which we were just chatting about before the rest of you joined us a moment ago. Many things happening, changing, lots of proposals for new tools, new ways of thinking about antitrust. And we very much wanted to convene this event, first of all, to draw on the wisdom and experience of Professor Melamed, who's written a very fine article that we've shared with most of you already on antitrust law and its critics, but also to see what might be useful, because a lot of these issues don't come out of the blue. We're stepping into a situation where issues of this type have been dealt with in the past, and we can surely learn from that experience, from analyzing what's worked and what hasn't, and might be useful going forward in the future. I said I would say a few more words about Professor Melamed before I pass the floor to him, but let me mention he was, of course, a partner at WilmerHale, where he chaired the antitrust business, senior vice president and general counsel of Intel, and then most famously, the acting assistant attorney general in charge of the antitrust division in the United States, where I understand he once took Jonathan Faull out for an ice cream in Paris. But we'll see if that comes up in the conversation, or maybe it was the other way around.
The other way around.
We'll see if that comes up in the conversation. Professor Melamed, I absolutely loved your article, and if you have a moment, please take us through that, the very important points that you make. And if you don't mind, I'll end with a question that's entirely contemporary, because it's one that we're debating here in Brussels right now, as I'm sure you know. Has ex post failed? And if ex post has failed us, do we need ex ante? And if we're going to have ex ante, and as I'm sure you know, there are proposals out there saying that we need it and need it urgently, what do we need to do to make it work? I would probably end on those questions, but I very much would like to steer the conversation in that direction. And when you're done, we will give the floor to Jonathan Faull and open the floor to further discussion. Doug, thank you so much for being with us, and thanks for getting up so early in the morning.
Thanks. I'm glad to be here. What I'm going to do is talk about the ideas that I discussed in the paper from a slightly different sequence and focus, in part because the paper is entirely U.S. focused, and I'm going to try to draw some comparisons with Europe. And I'll end up with a couple of thoughts that will be maybe a jumping off point for a more direct discussion of the ex post versus ex ante question that you just posed. So there's a push to reform antitrust law from multiple sources. It's provoked, it seems to me, by a combination of rising populism on both the right and the left that decries free markets, globalism, and inequality, a growing body of evidence that suggests increasing industry and market concentration, and perhaps therefore the failure or the shortcomings thus far of competition law. And then, of course, I think maybe the biggest provocation has been the rise of the big technology platforms, Apple, Amazon, and in particular the social media and search platforms, which seem to have limitless economies of scale, scope, and network effects that both suggest an enduring monopoly, longer than Rust Belt monopolies that run into scale economy limits and so forth, and perhaps more troubling monopolies that can extend into adjacent markets. They aggregate data. That's their business model, at least for many of them. That raises issues of privacy, which, as you all know, are very particularly salient in Europe. They are the leading, I think, communications media now, at least in the developed world, maybe in the entire world. And in the US, at least, there has been a clear pattern over time of aggressive, some might say excessive, antitrust enforcement aimed at the then dominant communications medium. Over time, radio, and then motion picture theaters, and then broadcast networks, and then cable, and now the networks. And then finally, the tech platforms raise issues, are perceived to be a political threat in many ways. They are thought by many to exacerbate polarization, the dissemination of misinformation, and the breaking of effective communities and the like. Okay, so there's a big push for reform. To frame the discussion, I want to start briefly by a conceptual discussion of U.S. antitrust law, which at a conceptual level is really very simple. There are two elements to every U.S. antitrust violation. One is anti-competitive conduct. And although that's never been defined, I think it is safe to say it means the following: conduct that does not improve product quality, reduce costs, or reduce above cost prices. If it doesn't fall into one of those three buckets, it's anti-competitive conduct because it's not efficiency or welfare enhancing. And by the way, all of those categories, or at least the first two, can implicate both dynamic as well as static considerations and issues of innovation. That's element one, anti-competitive conduct. Element two is market power, an increase in market power caused by that conduct. And by increase, I mean more than the but-for world, more than the world would look like in the absence of that conduct. And market power means the discipline of the reduced discipline of the constraining effect of existing potential competitors. So increasing entry barriers, for example, can be an increase in market power in that sense. In Europe, as you all know, the law also prohibits, in fact, more directly and explicitly prohibits the exploitation of existing market power rather than the creation of market power. The U.S. has no such concept. In other words, we can't go after someone simply for exploiting market power, taking actions that are contrary to the interests of trading partners, increasing prices, for example. And that creates makes what I'm about to say conceptually a little bit of an odd fit for parts of European law. Okay, notice that U.S. law, with its two elements, is exclusively focused on economic welfare. It prohibits conduct that is anti-competitive, welfare reducing, if it has enough of an effect that we care about it, namely it harms market structure, it increases market power. That exclusive focus on economic welfare is the consumer welfare standard. It's a misnomer. That's what it means. It doesn't mean an exclusive focus on consumers as opposed to other participants in the economy. Okay. There are three institutional features about U.S. law that distinguish it from European law that I think are also important. One are the procedural differences, rules of evidence, examination, the like. We can set those aside. Those are not central to today's topic. The second is decentralized enforcement. U.S. antitrust law is enforced by, or can be enforced by 52 different government agencies. The Federal Trade Commission and the Justice Department at the federal level, and each of the 50 states. It can also be enforced by any private person, corporate or individual, that has been injured by a violation of the antitrust laws. When you combine the decentralized enforcement with the fact that U.S. antitrust law is a law of general application that applies to almost all commercial activities in the United States, with limited carve-outs for state jurisdiction and for some regulated industries, you realize, I think, rather quickly that everything a company does of any size is potentially subject to antitrust law. And that means that in the U.S., at least, the deterrence effect of the antitrust law is its most important effect on the economy. The biggest benefit in the U.S. Is not the big cases that we read about. It is rather the multitude of anti-competitive acts that are deterred by a sound antitrust law, and the many welfare. That are deterred, and the multitude of welfare enhancing acts that are not deterred by an overbroad or ambiguous antitrust law. And this means that, especially in the U.S., antitrust law needs to be predictable, so that the deterrence function can map to the social welfare objectives of the law. The second big institutional difference or attribute of the U.S. law is that in the U.S., the government, as well as private plaintiffs, must persuade a court of the soundness of its case before it can get a remedy. As you all know, in Europe, the Commission can get a remedy, can impose a fine, can terminate conduct, can prevent a merger, and then the parties go to court, and several years later they might get some kind of judicial relief. In the United States, it's very different. And that means that a court must be capable, by ordinary rules of evidence and proof, of persuading a court of the soundness of the case. There's no deference to the government in our court system. It means that the proof requirements are much more rigorous in the United States, much less likely, frankly, to have false positives. And it also means that antitrust law must be administrable by generalist courts. It is not a specialized discipline. Okay, against that backdrop, there is this big drumbeat in the United States for reform of the antitrust laws, and a big conversation is going on. And I believe that when that conversation is examined, there are really two very different conversations that are not connecting in any meaningful way. One push for reform is made by what might be called mainstream progressives. Frankly, I consider myself to be one of them, who will believe the antitrust law should be recalibrated to be more aggressive, but still focused exclusively on economic welfare. The other conversation by the populists. They're not really interested in economic welfare. They talk about it a little bit in their papers. They did initially. They've kind of forgotten about that now. But they were never, in my view, seriously interested. Their principal argument is that antitrust law should give less weight to economic efficiency and economic welfare, and that it should focus also on inequality of economic and political power. And in opposition to both of these groups, of course, are the conservatives who believe the competition law is sound as it is, and if anything has gone too far. Okay. Even if one shares the concern about inequality of wealth and economic and political power of the populace, which I do to at least some extent, I don't think the solution is to broaden the focus of competition law. For one thing, competition law is a case-by-case law. So it will decide individual cases, but it doesn't, in my view, offer a systemic solution to those much broader and very different problems. Second, and perhaps more important, there is no algorithm, no way of weighting these competing objectives. So, I mean, how is a court going to say, well, I have 3 units of inequality and 4 units of efficiency? How is the court going to decide? The implication is that if you tried to have competing objectives, well, let me say one other thing. If you have competing objectives, they're going to matter only if adding additional objectives would lead to a different result. The result's going to be the same in every case. Why complicate the story, right? So it matters only if you're going to reach a different result. So that means adding additional objectives matters only to the extent, not only to the extent, but only where doing so economic welfare, because it means you're going to reach a result different from the one you would reach if economic welfare were your only objective. And you would get there by competing interests that have no algorithm for their weighting, and the result would be arbitrary decisions, or at least decisions perceived to be arbitrary. That would reduce the legitimacy of the law. It would increase the likelihood of regulatory capture, because there would not be unequivocal principles by which to judge what the agencies are doing and by which to say, you're wrong, that goes too far. It would always be within their discretion. And finally, again, more from the U.S. perspective, I think, than from the European perspective. It would make the law less predictable, and that would undermine the deterrent function. So I think the important debate, maybe not the politically exciting one, and maybe even not the politically important one, is the debate between the mainstream progressives and the conservatives, whether the law should be reformed so that it will better serve the economic welfare objective. Now, I'm going to talk about U.S. law here because this is where the context in which I developed the argument a little bit. U.S. law is heavily influenced by a Chicago school of view that was written up in a couple of articles 30, 40 years ago, that false positives, mistakenly determining that a firm violated the antitrust laws, engaged in anti-competitive conduct or whatever, is a more serious problem than a false negative, mistakenly concluding that a firm did not violate the antitrust laws. The argument is a government decision blocking a transaction, prohibiting a course of conduct is irreversible in any reasonable period of time. But so a false positive can be really costly, but a false negative isn't so costly because the market will correct it. It was never well founded, but it had a powerful intuitive background force. Okay. As a result of this, U.S. antitrust law is very cautious in some specific doctrinal areas, predatory pricing, refusals to deal, two-sided markets and the like, and more generally imposes a very high burden of proof on plaintiffs that tilt a lot of close cases in the favor of the defendant. The progressives argue that there's substantial reason to question the calibration, the relative weighting of the risks of false harms and false negatives and false positives. They point to evidence of market concentration, which suggests that false negatives have been too common in the past. Lots of studies showing that merger efficiencies are rarely realized, suggesting that false positives are less costly than might have been thought in the past, and individual cases with mistaken outcomes suggesting that false positives seem very rare. So if we decide reform is needed, it seems to me there are three alternatives, kinds of ways of framing the refrain. One is to establish simple rules, per se rules, presumptions, or ex-ante rules, I think, is to anticipate a little bit the later discussion on Paul's question. And you could write rules that you think strike the right balance and avoid some of the concerns I was talking about the ambiguity of ex post application of competing, multiplicity of competing objectives and so forth. The problem here, we can talk about it at greater length, is error costs. Because no ex-ante rule, no per se rule is going to track precisely to economic welfare. There's always going to be mistakes built into it. A rule like that is worse, I think, than at least an unpredicted error with law, because since it's written down, it will directly affect the deterrent impact of law, because everybody will know that's the rule. And perhaps most important, writing down rules like that become ossified. They just last long after economists tell us, gee, we got it wrong, we need to recalibrate that rule. But that's one kind of alternative, to be sure. Another is to recalibrate ex post principles based on a different error cost tolerance. Rethink law in these various doctrinal areas. One area might be, for example, merger law, where in the U.S. law, a merger is illegal only if it is more likely than not to lead to competitive harm. Maybe we should change it, as others have suggested, to a balance of hardships, a kind of probabilistic look at it, so that we can say, well, here's a merger that has only a 10% chance of having a bad outcome, but the upside is very small, and the bad outcome, if we realize it, could be terrible. If Facebook might have revolutionized, not Facebook, Instagram might have revolutionized social networking, and yet it was arguably taken off the boards when it was acquired by Facebook. Maybe we should think of mergers that way. So maybe we want to recalibrate the standards. And the third alternative suggested by this when you consider the institutional constraints in the United States, the decentralized enforcement, the generalized courts, and so forth, you might conclude, and the general application, rules that apply to almost all commercial conduct, you might conclude that certain kinds of fairly cautious rules actually, all things considered, are optimal. I have in mind, for example, our very cautious rules on refusal to deal, where we don't want everybody who thinks a monopolist has an input he could use to compete to be able to bring an antitrust claim. So you might have a very cautious rule. And by the way, the constitutional differences from Europe, that implies that optimal U.S. competition law might be quite different from optimal European competition law. But you might say, in some contexts, those rules really don't work. Maybe those contexts are the tech platforms. Maybe with the tech platforms, we need a more aggressive refusal to deal law because we think that self-preferencing is a more serious problem because it allows extension into adjacent markets willy-nilly, or because we think that requirements, competition law duties of interoperability or data portability are really important to reduce entry barriers, either to adjacent markets or to the core market. And therefore, we need an aggressive law. And that might lead to this, in the U.S., rather radical thought that maybe we need sector-specific competition law geared to particularly problematic sectors for which the laws of general application are less suited. And with that, I will turn it over to Jonathan.
Well, okay. Well, if I may, while Jonathan unmutes himself, first of all, thank you for that, Professor Melamed. I very incautiously left out two very important announcements at the beginning. One is, unfortunately, Stephanie Yoncourtin has been called to a Renew Europe session and will not be with us today. Things are rather chaotic over there with a lot of very big business going through the European Parliament, as I think we all know, and she sends her regrets. Secondly, I see here there are no questions in the chat room, but before I hand the floor to Jonathan, let me just say we'll get to as many questions as we can, and the best way to do that is pop it in the chat room, and I will call on you a little bit later as we see those coming in. Jonathan, plenty to think about there and to respond to, and I'll hold my questions for later. If I may, just one more thing, because I did say I would announce you better than I did at the beginning. Jonathan is, of course, for those of you who don't know, a three-time Director General, Justice and Home Affairs, also FISMA, the Financial Services, and finally Brexit. And for many, many years was a pillar of European competition policy. He served as Deputy Director General there in charge of state aid. And for those of you who don't know Jonathan, I hope I'm not embarrassing you, and I hope this is true, but I think much of what we call the competition regulation today, he actually authored at some point over the years. So thank you. Thank you for that. We look forward to hearing what you have to say. Is anything broke that needs to be fixed? And
that is the question. Good. Thank you, Paul. That over generous introduction, very unfair to lots of other people with whom I worked over the years. But I'm very pleased to be here. Very pleased to be seeing Doug again. He and I worked, I think, together most of the time when he was in the Justice Department and I was in the Commission in interesting times. And I see a lot of familiar, not so many faces, but names because they've turned their cameras off in the audience. So I look forward to a good conversation. I will be brief. I think I will say two separate things, or divide my remarks into two separate chapters. Is the EU, does the EU have competition law which neatly divides into ex-ante and ex-post? And then secondly, is digital different, and is whatever difference the digital economy or digital products and markets have in comparison with more traditional products, does that justify radical reform of competition law? Now, the EU doesn't break down easily into ex-post and ex-ante, by which I mean ex-post, you wait until something has happened. You have to wait until something has happened before you apply the law to it. ex-ante is that you take certain precautionary measures. You don't have to wait until the current set of offences, at least, has been committed before acting. Now, I'm going to put to one side state aid law, to one side public undertakings law. I'll concentrate on Articles 101, 102, and the merger regulation. So if you take those three competition laws in Europe, it's quite interesting. 101 is today ex post. There is no longer what was in all of the formative years, and my formative years in the European Commission were dominated by this debate as well. The system initially was very much one of the European Commission requiring notification of agreements and then saying what it thought of them. And gradually that system collapsed. It collapsed under its own weight after pragmatic reforms, the invention of comfort letters, the invention of the block exemption regulation technique, which began to become a straitjacket, and eventually the system was quite radically reformed into what it is today, which is a more decentralized system, not as decentralized as the one Doug has described in the United States, and a system in which you can't go to the Commission and say, this is what I want to do, is this all right? The Commission and the other bodies responsible for enforcing Article 101 may intervene, as indeed may in certain circumstances the courts. 102 is different. 102 never had a notification system. 102 is, at least at first sight, utterly ex post. An abuse of dominant position has to happen for it to be prohibited, and those who seek to have it prohibited have to demonstrate to the satisfaction of the authorities and ultimately the courts that an abuse of dominant position in a properly defined market has taken place. Although, again, in the way practice has developed with the widespread use of remedies in all of the various aspects of competition law, the Commission has introduced through its remedies practice some preventative mechanisms, particularly in the case of 102, which are designed in cases settled by remedies where there has been an abuse of dominant position, designed no doubt as well as it can be done in advance to prevent future abuses of what would remain, at least until further notice, a dominant position. And then you have the merger regulation, which in the European system is indeed a notification system. Mergers which meet the various jurisdictional requirements cannot be consummated until they have been approved. So you have a mixture of ex post and ex ante rules, and in the development of the procedural mechanisms to apply those laws over the years, you have had a gradual relaxation by the Commission itself of what was its essentially monopoly position in the early years for the application of Article 101. Now, why is this debate taking place? What is wrong with the world in 2020? Well, there are lots of things wrong with the world in 2020 beyond the scope of this discussion. The main revival of interest, I think, in the fundamental paradigms of competition law are down to two things. One is there are periods, fashions, seasons, generations in the development of competition law, and there has been a consensual dominant paradigm for quite some time, with all sorts of debates in the academy, among practitioners, among officials taking place, but within reasonably well understood boundaries about what consumer welfare should or should not be, what modern techniques should be used, but always within the same general parameters. Is it time for a change? Is the system broken? Does it need to be replaced by a new one? Is something that may have been happening now, even if we were not, and this is the second reason, if we were not faced with what seems to be a new industrial revolution where the digit data have replaced coal and steel as fundamental inputs and resources for large parts of the economy. Look at what we're doing now. Think about how we bank in all sorts of different ways, in all sorts of different markets. Data transmission and protection have become very fundamental issues. Now, does all that justify another look at competition law, which it is true was built, and look at all the precedents we know about, was built on coal and steel and cars and things that were made in factories and you could physically touch. There's an additional European feature to this, which is a very strongly held fear that this industrial revolution is one in which Europe is a bystander and a consumer rather than a protagonist and let alone a leader. Maybe true, maybe not true, but the sense that the digital economy is one which comes from the 5 square miles around where Doug is sitting in California, or increasingly in China, and Europe is in the middle consuming things that other people are designing and making, is a strongly held view, which has led to the whole discourse about European sovereignty, strategic autonomy, European champions. All this comes at the time of Brexit, when United Kingdom is no longer at some of the tables at which these things are being discussed. The United Kingdom, a country which might have been expected, at least until very recently, to oppose those views. So those are, I think, some of the reasons why these issues are being discussed. A commonly heard view is that the current tools of competition law are not sufficient, are not adequate to deal with the apparently unassailable market positions. I've heard people use that expression. It seems to me a vast exaggeration. I don't know how many apparently unassailable positions in markets which might have been identified 150, 30 years ago are still held today. I think very few, if any. I also believe personally, I'm not sure whether this puts me in Doug's conservative camp. I think that competition law practitioners, thinkers, enforcers, even academics should be rather humble and modest about their ability to foresee market developments, and therefore that the burden of proof on those who want radical change to justify it is a relatively high one. Of course, market power is hard to prove, and markets are hard to define, and they are harder to define when they are expanding rapidly, both in breadth and in depth. And it may appear that some combination of high barriers to entry, network effects, and vertical integration are cementing market positions which will make penetration by newcomers more difficult. If you believe all of that, then I think you will accept that the current rules need either to be reinterpreted in ways which courts might find excessive, or rewritten in order to provide a more sound, at least legal basis for what amounts to a new type of competition law. I'm going to leave it in the form of questions rather than answers. But I will add a fair to that. I think we need a great debate. I'm not sure we're having that debate. I'm not sure this is a particularly good climate, a particularly conducive climate to that debate. We are in a massive public health crisis, obviously, which is why we're doing this the way we're doing it. And we do not know how profound the economic consequences of this crisis will be. We don't know how long it will last, and we don't know who will be left standing and in what state when it finishes. There is, however, at least in Brussels, there is considerable political momentum behind the need for change. This European Commission came into office before COVID-19 with a very strong political commitment to doing something important and radical about the digital economy and making it more European by applying European values, interests, and law to the way it operates and to the outcomes that the application of the law is to bring about. So it is expected that the European Commission will come out with some radical legal proposals relatively soon. And an ex-ante tool is one of them. So there will be, everybody expects, there will be provision for either a return to, but that's not the right way to put it. It's not a return in history. It is a new way of apprehending the problems of the digital economy by giving powers to someone or someone's to intervene and stop things happening before they reach the level of violation of what is today the substantive provisions of competition law.
Okay, thank you for that, Jonathan. If you don't mind, I'm going to abuse the microphone yet again. And I'd like to go, first of all, back to Professor Melamed and offer you the opportunity to respond to anything you heard Jonathan say just now. But let me toss in my own question. You said quite early on that one of the problems with ex-ante rules is that they tend to become ossified. That was the word that you used. I wonder if you could elaborate a little bit more on that. How and why do they become ossified, and what are the consequences of ossified rules? And if I may also, from reading through your article, you had some interesting things to say about the experience with quick look decisions in the United States. I'd be curious if you could share a little of your experience on that. Thank you.
Sure. Well, the first question that you asked, Paul, is very relevant to what I wanted to say in response to Jonathan. I had in my own mind, I guess, imagined that ex-ante implied some kind of regulation, some kind of specifying the rules with some degree of detail. And as I said, I think one problem with that is that the rules are never going to be perfectly, mapped perfectly to the objectives, unless you have tens of thousands of pages, I suppose, like a tax code in the U.S. So you'd always have some what I call specification errors, false positives, false negatives built into the rule. And then the ossification point was, if you have a rule, you have expectations that develop around it, you have rationalizations that protect it, you have businesses that organize their conduct in a way that takes advantage of those rules. They find ways to, in effect, engage in arbitrage or otherwise to profit from that structure. And then they become powerful forces lobbying against changing them. So for all reasons, reasons of slowness of the political process, lack of sort of intellectual, infinite intellectual fluidity, and then capture of a sort. Rules always, it seems to me, in my observation, seem to outlive their usefulness. So that was the concern I had about rules. Now, Jonathan quite rightly describes a different kind of ex ante, which is case-by-case adjudication in advance. A mother may I, as some people call it. You go to the government and you say, can I do this? And I'm not saying that's always a mistake, largely for the reasons Jonathan pointed out at the end, which is we may be faced, at least with some sectors, with such serious problems of if we don't move quickly, the horses out of the barn, the damage is done, sort of thing. That maybe we need that. But I want to just mention, I think there are three serious costs to an ex-ante, a case-by-case ex-ante regime. One is delay. The entrepreneur has an idea, and now he's got to wait for the government. And at least in the U.S., if you get a senator to write to the agency and say, I'm very worried about this because some commercial interest that stands to be disadvantaged by that conduct gets to the senator, then you can have all sorts of delay. That has obviously both transaction cost problems and deferred benefit of the transaction if it's a desirable transaction cost. Secondly, it means that the agency is making decisions with very imperfect facts. One advantage of ex post is you get to find out a little bit about how did this actually work? What really are the facts on the ground? If you do it in the abstract in advance, the factual record is necessarily impoverished. And if you assume that those merging parties that I referred to earlier really believed that there were going to be efficiencies from the merger, and I suspect for the most part they did, maybe they were deluded by their own dreams of their own self-interest in coming to that conclusion, but whatever, they might have believed it, and then data suggests that they were wrong. The likelihood of just mistaken errors, decisions becomes, I think, greatly increased in an ex-ante regime. And that in turn exacerbates the arbitrariness risk because we don't have a good record to cabin the decision. And the third cost, I think, is what it does to the I've had a little bit of firsthand experience with this. I suspect many of the people on this meeting at this meeting have as well. When a company has an idea, and then it says, well, I've got to go to the government and get approval. You then start asking, am I going to get approval? How long will it take? Well, it'll be better if I change it this way and that way. And what you have done, it seems to me, is potentially throw a big wet blanket over entrepreneurship and innovation. And you've induced a kind of caution in the business community. And going back to Robert Solow, we all know that innovation is a much greater source of economic well-being than avoiding deadweight loss. So that's a potentially enormous cost. It gives me some caution about reverting, as Jonathan put it, to what I call the mother may I form of case-by-case ex-ante approval requirement. Paul, remind me the second part of the question you asked me. Quick
look decision tools.
Oh, yeah. Okay. So as I said, one of the advantages, it seems to me, of an ex post, obviously there's a real serious disadvantage, which is you may not be able to get an adequate remedy. But one advantage is better facts. One problem in U.S. law, however, it has been because of this risk tolerance and the resulting high burden of proof, is that huge amounts of evidence are explored by the agencies, if it's a government case, and by the courts. That often both prolongs decision-making and transaction costs and the like, and I think tends to bias cases against plaintiffs because records become complex and generalists often it would appear, if you read some recent U.S. opinions, don't have a clue what they're doing. So one solution is to have some shortcuts that say, yeah, we want to have ex post, we want to know a lot about the facts, but we don't need to turn over every stone. So maybe we can have some quick look rules that say, if a transaction has the following attributes and the market has the following attributes, plaintiff wins, or at the very least, a burden shifts to the defendant to prove something quite tangible to justify the transaction. It's kind of a way of I suppose you could say, moving a step towards ex post, not temporally, but in terms of the degree of factual digging that the fact finder goes into, expediting the resolution of the matter, and maybe recalibrating the risk tolerance a little bit.
Okay, great. Thank you. I'd like to call on Guido Lebrano, if I could. And I think, Krista, you need to unmute his microphone for him.
Yeah, thanks a lot, Paul, and thanks for the very interesting presentations. My name is Guido Lebrano. I'm with the Information Technology Industry Council. We're a trade association representing tech companies. We're very engaged in the discussion that is going on in Europe on reform of competition law. And I have a question that is actually building up on Professor Melamed's comments, and also to a certain degree on Mr. Faull's experience with European competition law. The ideas that the Commission is considering relates to this new tool that would allow the Commission to intervene and impose behavioral structural remedies regardless of a dominance situation, and also regardless of an anti-competitive conduct, based on an assessment that a certain situation or a certain market is not functioning optimally. And this is obviously a significant departure from current EU law, but also seems like further away from the standard in the US on consumer welfare. So my question is really, what would you say are the preconditions that would justify such a bold change from existing competition law, if there is any that does? Thank you.
Well, I want to make sure I didn't mishear you. Did you say intervention even absent any competitive conduct and dominance, or intervention because of dominance even in the absence of any competitive conduct?
So this is based on a consultation document that the European Commission has published earlier this summer, and it broadly describes a potential tool as applicable in cases where there is no dominance, and also then into situations or conducts that may not be deemed as anti-competitive in case of dominance in current rules.
Well, I find, I confess I haven't read that paper, so maybe I'm missing all the wonderful rationales and justifications for it, but I find it very, at least presumptively, very unattractive. Because it's one thing to say, look, this firm doesn't have dominance, but it's engaging in anti-competitive conduct that could do some real harm, so we ought to intervene. I understand the logic for that. I also understand the logic to say, well, here's a firm it's dominant, it's lasted a while, it appears to be situated to last a while in the future, and maybe we ought to intervene in some way to either break it up or constrain its behavior. I'm glad to talk about that alternative, because I think there is a perfectly logical, sensible set of criteria one could use to justify that. But the idea of taking a firm that is not dominant and not engaging in anti-competitive conduct and regulating it just strikes me as a throwback to, old-fashioned public welfare regulation, which I think has all the problems I talked about of error, cost, ossification, discretion, political capture, and all that. I guess it sounds to me like a pretty terrible idea.
Okay, thank you. Professor Zisman, I believe you have a question as well. No? Is Professor Zisman here? Who's posted the question from guest?
Not I.
Not I. Okay, good. Well, who is TCal 0302? Could you introduce yourself and ask your question, please? You're muted. Chris will get you in a moment. Sorry, you're muted still. I think you're on now. No, there seems to be.
Well, maybe we could just try paraphrasing the question from the chat.
Yeah, exactly. It's been written here. Sorry, your microphone's not going too well. Professor Melamed, would you like to have a go at that?
Sure. So the question, as I understand it, is picking up on my explanations for the caution in U.S. antitrust law, and perhaps the explanation for why what I think is optimal U.S. law might not be the same as substantively optimal U.S. law might not be the same as substantively optimal EU law, and suggests emphasizing more than I did certainly that the problem of the private plaintiff in the United States, which cannot be is less likely than a government agency to think that it's supposed to act responsibly in the public interest. It might be opportunistic. It might be bringing a lawsuit simply to extract some kind of favorable settlement or whatever. And the question pointed in particular to predatory pricing law. I think that's clearly correct. That the availability and the common use of private litigation in the United States, I think, does explain a lot of the caution in U.S. antitrust law. There's a fear of, frankly, of arming the private plaintiffs with an opportunity to just engage in what are called strike suits to shake down a company for damages. It used to be a joke among those of us in the big firms that mostly did defense work, and we would fly into the town for the hearing in court in our flying first class in our fancy jets and so forth, and we would always laugh at the ones who were coming in the private planes are the plaintiffs' lawyers. So that is a concern and has been. I do think in the United States that one of the problems for that is class action law. Because what often happens in these cases is you litigate whether the class can be certified. And it's big enough, the defendant says, I've got a 90% chance of winning and a 10% chance of losing $5 billion. I think I'll settle. So the availability of private remedies with all of the accoutrement that accompany that has certainly driven a lot of U.S. antitrust law, explains a lot of its caution, and I think does add to the reasons why U.S. antitrust law is and ought to be more cautious than European law, although I don't know what the future will hold with private remedies in Europe.
Okay, thank you. Jonathan, do you want to say something about that? No, can you unmute him, please?
Yeah. Can you all hear me?
Yes.
Thanks. By the way, the question asked earlier was by my colleague now, the Brunswick Group, and great US and European enforcement regulator, Terry Calvani. So Terry should come back in a second.
Hi, Terry.
He's also up in the middle of the night where he is, I think. The one thing that's important, I think, to remember in response to what has just been said is, again, to understand the climate in Brussels. There's a feeling that the big fines haven't worked. I remember the days when 100,000 euros was considered to be the psychological barrier. We'll never do it. It'll be too high. We did it. The world somehow continued to turn. Now it's all, of course, in zillions of euros, but stubbornly, the problems remain.
Nothing happens.
That's the way people see it. The dominant companies or the near dominant companies are still dominant or near dominant, and their behaviors don't change. That's the perception. Again, maybe unfair, may not be fair. Unilateral conduct falling short of a dominant position is hard to reach in European competition law. We know that. I nearly said impossible, not entirely. The power to break up companies, which the Americans have, we don't have in Europe. nor do we have the power to reopen in nearly all conceivable circumstances mergers once they've been approved or once they've gone through because they didn't meet various thresholds to be checked in the first place. So all of that, as a matter of fact about the state of the law, forms the background to why people think we need something different, we need something new. The ossification threat, which Doug referred to, is of course a very real one. The more detailed the rules you have, the more lawyers begin to treat them as a code and a template and copy them. And some technology comes along which makes them look silly, but meanwhile, there is a great deal of lost innovation. The example in Europe, well, there are many of them. The example of Europe probably is the patent license regulation, which was a very detailed block exemption regulation, which said you don't have to notify your patent licenses to me anymore as long as they meet the following conditions. And there was a list of things you can do and a list of things you can't do and a list of things you may do. And lawyers began just writing contracts, whatever the economic reality, with all that language in them. And gradually the internet came along and made them all look very silly, because the distinction between active and passive sales, which was at the heart of a lot of European law on distribution and on patent licensing, which said that you could prohibit soliciting business from one country to another, but you couldn't prohibit responding to demand for business from one place to another. That was the compromise in the name of the nascent internal single market. Well, of course, the internet makes a mockery of where you are when you're advertising. What does it mean to solicit a sale in another country? You don't have to take out an ad in the local paper anymore. So the danger of ossification is a very real one. It's known, I think, in all areas of the law. It's particularly harmful in competition law because it stifles innovation. Since, as I said earlier, you don't get an opportunity to do a root and branch reform of competition law more than once a generation, if that, whatever we do in the next year or so is likely to hang around for quite some time in what might be very different circumstances in 4 or 5 years' time. So again, humility, caution, modesty would suggest that we think very carefully about what is broke before we set about mending it. That doesn't mean that everything is intact. There are things that are broke. There are things that need addressing, and we've talked about some of them today. I just hope that the lawmakers take the time, conduct the proper consultations, and if possible, and it may be slightly more possible this week than it was a week ago, that there is transatlantic cooperation in this field. If we are going to reform competition law, I hope at least that the Europeans and the Americans, and I would add the British, do this in a harmonious way.
Good. Well, thank you, Jonathan. By the way, you reminded me at the onset that I did neglect to announce your current affiliation. Jonathan is, of course, director at the Brunswick Group here in Brussels, director of public policy. I have a question from John Higgins. We'll take one more and then we will move to conclusions. I do apologize. We're going to be maybe 5 minutes late. We won't go on forever, but if you could stay, the best is yet to come in the next 5 minutes. So John, it's nice to see you online, and the floor is yours.
Thank you very much, Paul, colleagues. If I can sort of, as it were, cut to the chase. I mean, I think both Jonathan and Doug, the political momentum, the political pressures building up to, as it were, do something. I thought, Jonathan, you described very well, you know, that what's behind this is a European fear that Europeans are bystanders and consumers, as you put it. I mean, Nelly Cruz used to talk about us being becoming the people whose contribution to high tech was the guys with the credit card. And I thought she put that very well. But also, Doug, I mean, you described this difference between those who are approaching competition law as an economic welfare challenge, as it were, and those that the populists who are picking it up and saying it's an inequality issue, and maybe that's we should do something about it from that point of view. And also, as you both said, this idea that somehow GAFA's becoming too powerful. You hear it all the time in so many different quarters. So my question, I mean, to Doug, in a sense, I think Jonathan's answered it a little bit by saying, let's be cautious and humble. But my question to both of you, but particularly Doug, is the European Commission grasping at the right tools here? I mean, if we accept it's an issue that somehow that GAFA is too powerful, and I don't necessarily accept that, but if we did, I mean, are we in the right place looking at competition tools in the first place to try and fix it, or is there something else that could be done?
And let me just, Doug, before you go, John, if you could introduce yourself briefly as well, please.
Yes, I'm sorry, Paul. Yes, John Higgins. I used to be Director General of Digital Europe. Now I do a number of things. I'm President-elect of the BCS, which is the Chartered Institute for IT Professionals in the UK. I also chair a global think tank, primarily focused on tech for good, I suppose I could put it that way. Yeah. So it's the grind apart from making the best of this stuff for all our benefits these days.
Okay, thank you.
Short answer to your question, John, is this. I think there are serious issues raised by the tech platforms. The privacy question is an important one, and the political impact question is an important one. I don't think either of those is suitable for regulation or by competition law. I think competition law should focus on economic welfare, for the reasons I said, and that with one exception, it should require proof of anti-competitive conduct in the sense that I defined it as a necessary element of intervention, and the intervention should be focused on prohibiting such conduct and remedying the consequences of that conduct. The one qualification is, I think there is a potential argument that would say, well, if you have an enduring monopoly that's lasted a long while, appears likely to continue to last, appears to be having significant adverse economic impact on welfare, where the investors have already received ample reward for their innovation, so intervention is not going to deter other investors in the future. And there's a kind of intervention that might ameliorate some of the costs of their ongoing dominance. That's the answer, but we probably stumble. But if there were, then I don't think in principle it would be wrong to say, bust them up or put in a no preferencing rule or something like that to deal with a very specific sectoral problem. But as a general matter, I think competition law ought to stick to its knitting and ought to require anti-competitive conduct, because otherwise I think it's going to do a lot of harm from an economic perspective and from an innovation chilling perspective with very little benefit elsewhere.
Okay, thank you. Now, normally this is the moment when I would step in with some concluding remarks, but let me just say I'm a very lazy man and it's very late at night. So I'm going to ask our two speakers to do this, if you don't mind. We'll come to Jonathan first, and then we'll go to you, Doug. But Jonathan, maybe I put it to you in the form of a question. What will you take from this discussion with you this evening? And what advice would you like to leave? And maybe that advice could be in the form of do's and don'ts.
Well, I thought I was warning against do's and don'ts. I would advise everybody to read Doug's article, by the way, because it sets out, as he has done today very clearly, the debate which Europeans don't often see through American eyes. And it's good to know that the debate is taking place there. And as I said, and I won't beat about the bush, as we look forward to a Biden administration, I think that will facilitate transatlantic cooperation. And these are things that we should be talking about together at all levels, government to government and people like us. The circumstances are different. There are specific European issues, as has always been the case. I would make one comment on what Doug has just said. I agree that competition law should do what competition law does best. And if we fear that it is being stretched to deal with things that other parts of law and policy are better placed to deal with, and maybe deal with more democratically, then I think we should argue that it has reached its limits, and regulation and legislation based on other policy objectives should go through their normal processes, which again are normally more democratic and require more democratic input than the mandate that competition authorities have. With one exception, I think data have become an input into a very important part of the modern economy. And therefore, it is right that competition law should think about and make judgments on the way companies collect, process, administer, buy, sell data. It's cold. It's the input of today, and therefore, if you have a cartel about data, you have a cartel. And if you abuse a dominant position in respect of data, you're abusing a dominant position. So data can't be ignored. And since data are heavily regulated, quite rightly, to the level, by the way, in the European Union of constitutional principle of fundamental right in privacy and data protection, then those interests, those values have to be brought to bear on competition policy analysis. So I think it is legitimate for companies to use as sword and shield the importance of privacy in the way they behave, and expect the competition authorities as well to take that into consideration.
Okay, thank you for that. Doug?
Just two brief thoughts. On the last point that Jonathan, with respect to data, privacy is has a very different status in the European law than in U.S. law. I guess I disagree with Jonathan. I think the data clearly has to be looked at as an asset, as part of the economic analysis. Was it unlawfully acquired? Is it being unlawfully used? What are the, what is the implied price and so forth? Those could be an important part of competition analysis. But I don't think that privacy protection unrelated to economic welfare analysis ought to be an input into competition law decision making. That ought to be regulated separately. I want to add one other thought, which is a little out of left field, but I think it's important as we have, in effect, transatlantic conversation. One of the United States' many exports, is the concept of effects-based extraterritoriality. That is to say, the United States can bring a competition proceeding challenging conduct undertaken by a French company in Germany if that conduct has an adverse effect in the United States. Conceptually, it makes perfect sense. We shouldn't be disarmed if somebody in Germany is sending missiles into the United States, vice versa for the Europeans. But that has tremendous implications for economic welfare. Not just because one country might disagree with another about the appropriate criteria and standards for intervention, but because multiple jurisdictions looking at the same conduct has enormous implications, transaction costs and the like, and a significantly heightened risk by the way of false positives. Because country A can have a false negative, country B can correct it. Country A has a false positive, country B can't correct that. So I do think that as our two jurisdictions consider reforming our laws, and particularly applying them to firms like the tech platforms that deal largely in multinational or global markets, we need to be mindful not only of our own criteria for optimizing the law, but of the impact of our decisions outside our jurisdictions, not just on the defendants in the case, but on the conduct by economic actors throughout the world.
Yeah, thank you, Doug. And I didn't hear any do's or don'ts.
Well, I mean, implicitly, don't broaden the mandate of competition law to consider non-competition objectives, including even privacy, and be thoughtful and careful.
Well, I was going to say, there you go. That was definitely a don't that I heard there right at the end. Look, now I have really three quick things to say. I'd like to have a favor to ask of everyone here. Could you all please put your cameras on? And as you're putting your cameras on, please remember to smile. And once your cameras are on and you're all smiling, I hope you'll all join me in thanking our fantastic speakers for animating such a fantastic discussion here. Oh, look at everyone. It's nice. It's nice to see you. Will you join me in thanking our speakers?
Thank you all.
Okay. Thanks to everyone. I'm sorry we ran a few minutes late. This is going to be a regular series and we'll resume again in about a month. I don't think anyone can reach the excellence of the two speakers we've had here tonight, but there's certainly plenty to talk about, and we'll be back in touch about that in the near future. Thanks for the time you gave us this evening, and I hope you've enjoyed this as much as I did. Thank you.
Bye-bye.
Right.